I'm Jennifer Lowe, the Director of Programs and Strategic Planning here at the Supreme Court Historical Society. I am delighted to welcome you to today's virtual lecture discussion on the legacy of Justice Robert H. Jackson. We are doing this in partnership with the Robert H. Jackson Center, and it is an honor to partner with them on this. Robert H. Jackson was a jurist whose eloquence, independence, and sense of constitutional balance continue to shape the law to this day. Our program features two of the nation's leading legal historians, each of whom has recently published a work on Jackson's life and thought. G. Edward White is the David and Mary Harrison Distinguished Professor of Law at the University of Virginia School of Law, and he joins us to discuss Robert H. Jackson, A Life in Judgment, a comprehensive portrait of Jackson's remarkable career from his early years as Solicitor General to his tenure on the Supreme Court and his service as Chief U.S. Prosecutor at the Nuremberg Trials. Professor White joined UVA after clerking for Chief Justice Earl Warren and is well known to our society members for his frequent participation in society programs, as well as being a longtime contributor to the Journal of Supreme Court History. Gerard Magliocca is the Samuel R. Rosen Professor at Indiana University's Robert H. McKinney School of Law. He joins us to discuss his new book, The Actual Art of Governing, the Youngstown Decision, and the Constitution of the Presidency. Professor Magliocca provides a penetrating reading of Justice Jackson's famous concurrence in the Youngstown Decision, which sets enduring limits on presidential power. His study explores how Jackson's pragmatic approach to constitutional interpretation continues to influence debates about executive authority. Professor Magliocca joined the Society last month in September for a lecture at the court on his Erwin Griswold Prize-winning book, Washington's Heir. Today, Professors White and Magliocca will help us to see how Robert Jackson's jurisprudence continues to inform society today. And as I said, we are deeply grateful to the Robert H. Jackson Center for the work that they do in preserving and advancing the study of Justice Jackson's life, writings, and enduring influence. We will begin with Professor White and Magliocca talking about their work on Justice Jackson, and then we will take questions from the audience. Please enter your questions in the Q&A box at the bottom of your Zoom screen. Gentlemen, the floor is yours.
Well, let me start by saying why I decided to write a biography of Jackson at this point. There were really 3 or 4 considerations. The first was that there had not been a biography of Jackson published for nearly 70 years. The last biography was called America's Advocate by Eugene Gerhardt, and Jackson participated in that book. So it's a very detailed book informed by Jackson's own papers, but it's quite unduly favorable of Jackson and lacking much analysis. So anyway, I thought it was perhaps time to do another one, and I was encouraged in that thought by the very rich collection of Jackson papers in the Library of Congress that for a while was not available to scholars. Then the Jackson family, the Jackson son and daughter, deposited them. COVID intervened and shut down the manuscripts division of the Library of Congress for a while, but I was able to get there afterwards. And any event, so I had a lot of archival base to do the book. The other principal reason was that I found Jackson just a unique figure. He is the last Supreme Court justice to have read for the law rather than gone to law school. He actually went to Albany Law School, but that was just for 1 year. He did not attend college. He grew up in Western New York and practiced law in Jamestown, New York. And he was very successful in practice, but he was largely a comparatively small town lawyer, not doing any with no particular emphasis on governmental work, particularly work involving the federal government. He was recruited by the Roosevelt administration. He resisted that, eventually agreed to join the Bureau of Internal Revenue in 1934. Within 7 years, he's become Solicitor General of the United States, Attorney General of the United States, on the short list for the Supreme Court, and eventually in July 1941 appointed to the court. He then goes on the court. He takes leave from the court to be the chief prosecutor at Nuremberg. So it's a remarkable career for someone with his particular origins. Last thing I want to say is that I had written on Jackson earlier, and I had the perception of him, which turned out to be realized in this book, that he was not altogether fulfilled in his work as being a Supreme Court justice. In some ways he wasn't a particularly good fit for the position, despite being very talented analytically and a very engaging, accomplished writer. And the reason for that was that he had difficulty with the collegial role of the justices. He chafed at efforts to try to persuade him to take positions that joined with other justices. He got into a feud with Black and Douglas fairly early in his career. It just wasn't. He wasn't best suited for that. I think the two roles that he most enjoyed were Solicitor General, where he was an advocate. He loved advocacy, and also developing the Nuremberg Trials, because he was, in addition to being the chief Allied prosecutor, he was the architect of the form of the trials, had to work them out with the other Allied nations, put a good deal of effort into it, and felt ultimately that he was vindicated, that the Nazi leaders had been disposed of properly, but they had been afforded a fair trial, and even a couple had been acquitted. So altogether, I found it a remarkable life, and I found him to be a very interesting and complicated person to write about.
Well, to sort of piggyback on those comments, I will start by saying that one of the reasons I decided to write my book about Justice Jackson's concurrence in the Steele seizure case is it is the most autobiographical opinion of any Supreme Court justice. That is, Jackson starts out by saying that his own experiences as an advisor to President Roosevelt were the most important influence in his thinking about separation of powers and presidential authority in the Steele seizure case. And then there's quite a bit in the opinion that directly references various professional experiences that Jackson had, either as Solicitor General, Attorney General, or at Nuremberg. And indeed, if you go through his papers, the same papers that Professor White referred to that are in the Library of Congress, you find even more autobiographical references in the early drafts that didn't quite make it into the final cut, but do give a good sense of how Jackson was trying to think through the problem, in a sense, in this kind of summation in some ways of his experience over a period of 15 years or so in the executive branch, then at Nuremberg, and on the court. So that was attractive because I didn't want to attempt a full biography. I knew that others were in the works. But also the Steele seizure case is one that every constitutional law student reads. It's cited and quoted over and over again by judges and scholars. And I wanted to try to write sort of the comprehensive book on that opinion. And really, the great mystery of the opinion to me is, how did this opinion by one justice speaking only for himself become this sort of authoritative statement about constitutional law, and in some ways a representation of the rule of law itself, at least for modern America? As Justice Jackson explained, he was writing only for himself. Professor White mentioned he wasn't maybe as collegial as other colleagues or other judges, and you could say that this was a reflection of that, in that he only wanted to write for himself and speak for himself. But somehow he managed to do that in a way that then sort of leaped beyond that limitation to become embraced by the professional community more widely. Now, part of the book looks at how did this opinion come to be written? So that required looking to some degree at some of the experiences that Jackson had prior to the steel seizure case and some of the sources that he used. Then kind of go through the opinion and think about particular statements or sections and how they, to some extent, relate to Jackson's experiences, but also carry more profound observations about government in various ways, which we can get into. And then finally, how did the opinion become canonical, right? And of course, the short answer to that is it became canonical during Watergate, when people were looking for a source that they could use to try to refute certain arguments that President Nixon was making about why he could keep the tapes to himself rather than disclosing them to the special prosecutor or to the courts. So there's a kind of biographical element to it. There's a kind of jurisprudential element to it. All of those were attractive. I mean, I don't know that I quite solved the mystery of how one person wrote an opinion speaking for himself that became a kind of gold standard for the rule of law, but the book is my best effort to do that. By the way, I do have Professor White's book, which I would urge you all to get when you get the chance. So just, I mean, maybe I'll just, if I could ask you a question just about, one of the things I found most compelling about your book was a section on Nuremberg, because there was quite a bit in there I didn't know. It seems pretty clear that he was a changed man after Nuremberg. So I don't know if you wanted to talk a little bit about like what that experience did to him or how it shaped him.
I think that, well, first of all, I think it was a welcome relief going to Nuremberg after the difficulties he was having inside the court. He and Justice Black had gotten into a dispute over whether Justice Black should recuse himself in a case in the spring of 1945, and Jackson had made it very clear that he wasn't going to agree to a strategy of Black's to just deny the rehearing petition that suggested that Black should recuse himself. That because that was the individual responsibility of justices, Black ought to take the heat for that, and Jackson wasn't going to allow the court to just simply deny it without any reference to the practice of judicial recusal. So he wasn't getting along with Black. He wasn't getting along with Douglas. He had been mentioned prominently to succeed Stone as Chief Justice. Black and Douglas had allegedly gone to sources close to President Truman and indicated that they did not take kindly to Jackson's being on the list for being on the Chief Justice and might even resign from the court if he were named. In short, he was not happy on the court. And when it was proposed that he go to Nuremberg and establish an international war tribunal, he jumped at it. So he went there with a feeling that, I want to do stuff from the ground up. I can have an impact. I want to communicate the message that we are not departing from the rule of law, even though we're trying these clearly very evil men. And he had to work hard at it. So it was a liberating experience for him. At the same time, he became impressed about the capacity of totalitarian regimes on both the right, Nazi Germany, and the left, the Soviet Union, to not only repress speech, but to encourage other forms of expression that could lead to violence. And so I think he went back to the court after Nuremberg with a chastened conception of the limits of free speech. I think he thought, after all, he's the author of Barnett, which is one of the great free speech opinions in the canon, and a very speech protective opinion, tying free speech very closely to the idea of democracy. But then he goes back and there you get some communist cases involving demonstrators, fascists or communist demonstrators, where municipalities are seeking to repress the speech, and he begins to take a more nuanced view. So I think Nuremberg was important in that. Indeed, in one of his opinions, he quotes from Mein Kampf, and sort of to make a point about how uh, speech when shaped by a totalitarian state can actually reinforce the supremacy of the state. So I think Gerard, Nuremberg is very important for him.
I mean, one thread that seems to me to go through his career is this feeling that we have to think, or this theme that we have to think for ourselves, whatever the problem is. We can't rely on precedent or what the framers might have thought about something to any great extent. I mean, he says that in Barnett, he says that in the Steel Seizure opinion, he says it in speeches. And in Nuremberg, of course, very much was a kind of thinking anew about a problem, right? Designing a trial that had never really happened before. And he was right in the middle of that. So you could sort of understand why he either was open to doing that sort of thing in a way that maybe others wouldn't have been, right? Or that it was maybe just a reflection of his own kind of self-educated, individualistic kind of upbringing, education, worldview, and so on, that he wasn't so in the thrall of past dogma with ideas or whatnot. And I mean, that may mean he was freelancing sometimes in a way that maybe some would say he shouldn't have been. But I do think Nuremberg, of course, was a very strong positive example of that, because they did create something from scratch that had lasting significance, and I think was able to earn the confidence of everyone who was involved. I mean, ultimately, as a fair kind of process, but one also that was just and sort of required. You know, it I don't know. I know that he shortly after the Steel Seizure case, he started writing this book about Roosevelt that he never finished. That then John Barrett, many years later, found the draft and kind of was able to publish in some form. Maybe not to talk a little. Maybe you could talk a little bit about his relationship with FDR, which was complicated. Though I mean, I think he respected the president, but he didn't sort of worship him. It seemed to me he had some critical distance from him. But I mean, what impression did you come away with there?
Roosevelt is the single most important figure in Jackson's career. Uh, Roosevelt or his administration is responsible for every single promotion in government that Jackson had between 1934 and when he went on the court. Jackson is consulted very frequently by Roosevelt when he's Attorney General, and they're beginning to consider America's entrance into the war. Jackson is the author of the Destroyers for Bases Agreement, and Jackson is the author of a memorandum that suggests that America can do certain things even though it has not yet achieved the status of an ally. It's still a neutral, not yet a belligerent. Uh, Roosevelt is very positive. Jackson writes, for example, the Struggle Against Judicial Supremacy, which is a book that tries to sort of justify the court packing plan, not so much because the plan succeeded, it did not, but because in the end, the Roosevelt administration's attitude toward constitutional law prevailed. Roosevelt was in the habit of consulting Jackson on a variety of matters informally. He took Jackson on fishing trips with him. Jackson very much admired him. In That Man, the title of Jackson's biography, unpublished biography that John Barrett retrieved, Jackson does a kind of list of Roosevelt's strengths and weaknesses, and among the weaknesses is that of being an economist. Uh, Jackson's view of Roosevelt was that Roosevelt had a kind of moral attitude toward economics, that if you did something that was clearly selfish and bad, you ought to get punished, whether what you did was economically efficient or not. Um, but Roosevelt had tremendous strengths as a politician, as a companion. Um, he was strikingly informal with with his aides and associates, but at the same time clearly uh, communicated the limits to which they could go. He was ultimately the authority. And so it's a very fascinating portrait of Roosevelt by Jackson, but Jackson, a cardinal virtue for Jackson, a cardinal principle by which he conducted his professional life was independence. He regarded himself as an independent person. He was going to work out his own views on legal issues. He was going to go his own way professionally. He was going to turn down opportunities if he felt that was appropriate for him. Um, uh, it, he he strongly resisted efforts on the part of his colleagues on the court to entice him to join their views. Black was notorious for trying to line up views that reinforced his own with cases, and Jackson resisted that pressure. Uh, so even though Roosevelt is clearly his most important mentor and the person the person with whom he was closest in political life, Jackson retains his sense of independence throughout.
Yeah, it's interesting because one of the things that makes the steel seizure opinion powerful is that people say, oh, well, Jackson had been an executive advisor and now he was ruling against the president. Not the same president, of course, President Truman, but that represented a kind of the difference between being an attorney general or in politics versus being a judge. Now, of course, it's a little more complicated than that because when Jackson was attorney general, he didn't always agree with Roosevelt. He didn't always do what Roosevelt asked him to do. And in fact, you see that in the drafts of the opinion where Jackson talks about the fact that Roosevelt thought that the legislative veto was unconstitutional and Jackson thought it was constitutional. And they just didn't agree on that. And that was just one of many instances in which they disagreed. I mean, not in an unpleasant way, but just in a professional way. And so Jackson was independent minded as attorney general, and he was independent minded as a judge. And he didn't really, I think, see probably as much of an inconsistency between those two things as maybe we would now or others might have. And yet, because there's this thought that he supported exercises of executive power, but that Roosevelt took in the run up to World War II that were broad, that therefore he, in effect, changed his position on that sort of thing because he had become a judge and because he had seen the excesses of executive power at Nuremberg. So I think there's some truth in that, right? As you mentioned, that Nuremberg, okay, did have an impact on his thinking, but at the same time, maybe more gets put on that story than is really there, and is more of a through line actually between Jackson's executive experiences and his judicial experiences, or writings anyway. But that's just a hypothesis.
There's a passage in Jackson's papers that I think is very illustrative. He's talking about he began an autobiography in 1944 when he was on the court. And in one of the chapters, he talks about going on the court and the transition he needed to make from being an advocate to being a judge. And he said that the transition for him was very great, that he had really enjoyed strenuously arguing on behalf of positions for his clients. He didn't necessarily agree with all those positions, but what he really liked was the opportunity to advocate for them. When you get on the court, your role of you're not an advocate anymore. You're supposed to be a neutral, impartial arbiter. And Jackson said, I think that the transition is difficult, and I'm not at all sure that I've successfully accomplished it. And I think that's an revealing kind of statement, in that Jackson approached issues and cases on the court in a fashion where he quickly decided where he was going to come out. But then he wanted to write up his opinions in a fashion that demonstrated that he wasn't being an advocate here. He was upholding the rule of law, that his decision was ultimately principled. And I think he struggled with that. But preserving the rule of law and preserving the idea that judges were impartial was a very important credo of his as a judge. I also wanted to tell one story about his relationship with Roosevelt. Early in his career, Jackson was asked to bring a case against Andrew Mellon, former Secretary of the Treasury. Jackson was then at the Bureau of Internal Revenue, and they were suing Mellon for non-payment of taxes over a series of years. The Justice Department wanted to indict Mellon for fraud. Jackson said that's not going to work. The fraud case is very weak, and a grand jury in Pittsburgh, Pennsylvania, where Mellon is from, is never going to indict him for fraud. And the reply came back, you have to do it. Jackson then made out the fraud case and failed to get an indictment. The case progressed, and eventually Mellon was required to pay a certain amount of back taxes. But while the arguments were going on before the Board of Tax Appeals, Mellon's lawyer would, every time Jackson was doing the prosecuting, every time Jackson would score a point, Mellon's lawyer would announce that Mellon was giving a portrait that he had acquired. Mellon had acquired a number of European portraits in the 1920s, started buying up art in that period, and he had a marvelous collection. He announced that a national gallery was being created in Washington, and he was going to establish its collection with a series of gifts. So each time Jackson scored some point to his advantage in the prosecution of Mellon, Mellon's lawyers would announce that Mellon was giving another portrait, and quite rightly was within his rights to take a tax donation for that. So eventually, Mellon is successfully prosecuted for back taxes. Then Mellon dies, and the prospect of the National Gallery creation is progressing, and Roosevelt is very much a fan of creating the National Gallery. It's a wartime, it's a Depression setting, and the idea that the federal government can create a National Gallery and fund it is attractive to Roosevelt. So Roosevelt very much wants to do it, and an agreement is proposed where the United States accepts the gift of a national gallery from Mellon, and Mellon will donate the paintings to establish its collection. And Jackson says to Roosevelt, we shouldn't accept this. You know, Mellon has been shown to have not paid back taxes. We shouldn't accept a gift of this kind from someone with his record. And Roosevelt says, that's fine, I'm going to do it. Remember, you know, you're not running for office. And so each time there's another gift from the Mellon family to the National Gallery, Roosevelt tells Jackson, hey, there's another gift to your gallery. So I thought that's sort of a suggestive episode about their relationship.
Well, it's interesting to think that Jackson apparently coveted being Chief Justice, talked about it with Roosevelt, maybe thought it was going to happen when Stone died. But it strikes me he would have been a pretty bad Chief Justice, or he would have had a very hard time kind of corralling people when, first of all, given the strong personalities that were on the court at the time, but also that wasn't really his skill, as you've said. I mean, so it's kind of odd that he wanted to be Chief Justice so much. I mean, other than just I guess the title or prestige of that. Do you have any sense of why that mattered to him?
Well, I guess the first thing I'd say about that is it's not so clear to me that he really wanted to be Chief Justice. I think he would have coveted the prestige of the office. But he said at one point in his papers that he wouldn't necessarily have liked the administrative duties that went with it. But I would agree with you that he would not have been a particularly effective in the collegial role that the chief plays. The chief is a kind of organizer and potential consensus builder of his court. Let me give an example of Chief Justice Rehnquist. Rehnquist, when he was an associate justice, was very much out by himself. He dissented in a great many cases. He was often the lone dissenter in those cases. He was called the Lone Ranger because he wrote so many individual dissents. He was clearly not collegial in his behavior, not interested in necessarily going along with other justices. When he gets to become chief, his views don't change, ideological views don't change, but he's much more interested in consensus building. And he's Rehnquist would say privately he didn't think anybody changed their views in collegial discussion. He wasn't a great fan of going into conference and thinking that anybody was going to persuade anybody else. But he tried to steer the court in a direction that seemed to give the impression that it was more unified than simply a lot of justices falling out among each other. I don't think Jackson would have been capable of a comparable shift in his posture. I don't think that encouraging others to join opinions, signal that the court was being more collegial, suppressing dissents. I don't think that was his style at all. And I don't think he had harmonious relations with a lot of the justices on the court. He wouldn't have been a particularly popular choice. He was considered 3 times for the Chief Justiceship. The first when he was first put on the court, the second after Stone died, and the third after Vincent died. There was a lot of support in professional circles for succeeding Vincent with Jackson. Jackson was, at that point in the history of the court, Jackson is an ideological moderate. He is not a clear member of the what he called the cult of libertarian activists on the court, Black, Douglas, Murphy, and Rutledge in his tenure. He did not. His constitutional opinions were unpredictable and not necessarily easily characterized ideologically. And he was, of course, a person of great stature in the legal community. So there was a kind of write-in campaign for him, which never had a chance of succeeding because the nominating president is a Republican and Jackson has been a lifelong Democrat. But Jackson didn't dissuade anybody from supporting his candidacy. But I think, Gerard, that it wasn't really that he was itching to be Chief Justice, but rather that he would have just coveted the prestige associated with the position. And I agree with you entirely. He would probably not been very successful, especially in the collegial role of the chief.
One of the things that makes, I think, Jackson a great justice is that his opinions are so quotable. And it does raise the question of how much that matters for judging. The fact that you can come up with this aphorism that everybody remembers or some line that people can use over and over again that's different from perhaps a more solid analysis that's longer and not particularly memorable. He gave a speech famously when Learned Hand and Augustus Hand were being celebrated for many years on the bench, in which he said, quote Learned and follow Gus. And it seemed like his opinions tended more toward the trying to be quotable than worrying as much about the people following them. Though ironically, in the Steele seizure opinion, he did follow an opinion that Gus/Augustus Hand had written as a district judge, which had laid out this idea that whether Congress had authorized, prohibited, or said nothing about executive action was a relevant consideration in thinking about whether a presidential action was lawful. So, obviously he loved poetry. He was, very well read, and you see that in many of his opinions. And of course, you've written about many other judges, in your kind of earlier books. And I'm just wondering, like, as you reflect on it, how much does it matter that somebody like Holmes or Jackson or perhaps Cardozo could, kind of turn a phrase? And if you're not able to do that, you could still be a very good judge, of course, but you're not going to be remembered or have maybe greater lasting influence. Is that true? Or
I think for posterity, the ability to be an accomplished judicial writer is very important. The people whose names constantly are kind of echoed down the ages, John Marshall, Oliver Wendell Holmes, Louis Brandeis, to some extent Felix Frankfurter. Hugo Black, one of the better writers on the court. And Jackson, of course. There really only been two judges whose writings have been anthologized. Holmes is one, and Jackson is the other. Eugene Gerhardt published a book, not the biography of Jackson, but an accompanying book analyzing some of his opinions, in which he had an appendix called Jacksonisms, and he just collated a lot of vivid writing that Jackson did over his career. I have a chapter in the book on Jackson as a writer. And one of the things I found really interesting about him was, there's a group of writers that I think would be at the top shelf of literary quality. Marshall, Cardozo, Holmes. And with those three, they had an ability to dash off drafts that were very close to the finished product. And they wouldn't spend a lot of time rewriting their work. They just had an ability to kind of capture things vividly, almost on the first cut. And Jackson, of course, final products are like that. But it turns out that Jackson wrote and rewrote Gerard has noticed the number of drafts in his Youngstown concurrence. That's very common for all his cases. He wrote 6 drafts in Brown versus Board of Education, all in the form of memoranda to himself, trying to figure out whether he was going to join the court's opinion or write separately. And he did this over and over again, and he would enlist his associates in this, and his secretary, Elsie Douglas, his law clerks, and the people he worked with in the government, and they would go through draft after draft after draft. And I sort of speculated on why he did this. And I think he did it because he just loved writing. He was just very interested in getting things exactly polished or the way he wanted to say them. And he was a workaholic. I think one of the reasons he had heart trouble is he worked all the time. He's also very active physically and socially, but he worked very long hours. And one of the things he worked at was going through successive drafts of his writing. So I find that a very interesting quality in him. But I agree, Gerard, entirely that if you want to be remembered over time as a Supreme Court justice, you better develop a writing style that is accessible and vivid. Let me just give one unfortunate counterexample. I think Justice Souter was actually a very important figure on the court in which he served. He maybe have almost single-handedly retarded the development of the court rightward during his tenure. But he wasn't a gifted writer. He took a long time to write opinions. And when he did write opinions, they tended to be a little verbose and digressive and not really reflecting his analytical ability. So unfortunately, I don't think Souter is going to be very well remembered. If you're going through Souter opinions and looking for quotable passages, you're not going to find very many.
Thank you. I'm going to come in, and we've got some questions from the audience that we have that I want to make sure that we get to, although you've answered a number of them already. One thing that we always want to know from our speakers, and we'll start with Professor Magliocca, what surprised you as you were doing your research?
Well, okay, the one most surprising thing was to find that one of the sources that Justice Jackson used to write his opinion in Youngstown was a memo that had been written by a deputy solicitor general in the 1930s, Golden Bell, and that memo was confidential at the time, and was confidential actually until about maybe 10 years ago, and talked quite a bit about separation, about executive authority in sort of, we'll call them ambiguous circumstances. And so there are a number of things that Jackson used from that memo to write the opinion. And, one of the things to keep in mind is the Youngstown case was heard on a very rapid timetable. I mean, I guess nowadays we'd say something like it was like an emergency docket sort of case, meaning it was basically 1 month from argument to opinion and only a few weeks from the actual decision by the president to take the steel mills to the time that the court heard argument. So everyone was in a hurry. It helps explain why there were so many opinions in that case. And it's understandable that people were kind of looking for whatever sources they could use to put together the final product as soon as possible. But that was something that was not known before, that Jackson had used this particular memo. And so I thought that was both interesting, and I guess in a sense, it's like it gives a little bit of credit to the author of that memo, who was otherwise forgotten. And well, at least his name's in my book. I mean, and so that was the most surprising thing that I came across in the research.
What about you?
Well, Gerard, I just want to say with the Golden Bell memo, I just think it's interesting. Your last name is Bell, and you name one of your sons Golden. I mean, if you had a daughter, do you name her Silver? Anyway, Golden Bell, yeah, Golden Bell indeed coined the phrase twilight zone to represent the sort of intermediate posture where it's uncertain whether Congress has not explicitly authorized a presidential executive decision, but may have signaled that they approve it. Anyway, on my surprises, the first one was Jackson's relationship with Elsie Douglas, his secretary. They traveled to Nuremberg together, and they spent quite a good deal of time in each other's company in Nuremberg, including spending a week in Paris together. Jackson's wife did not accompany him. By all accounts, Jackson was happily married. I have a chapter on his family. We don't have a lot of letters, unfortunately, from Jackson to his wife while he was in Nuremberg. We have some. We have very little correspondence from her. It's a little hard to get much detail about their relationship, but it seemed to be perfectly happy. Kind of interesting that Jackson would have obviously Elsie Douglas, who was was widowed and had a son. She was obviously enamored of Jackson. They spent time dancing together. Now Jackson's son was along with him in Nuremberg. So I'm not trying to suggest that it was that there was a great deal of sexual interaction between Elsie and Jackson, but they were clearly attracted to one another. That was something that just came out of the blue. The other thing I'd say, Jennifer, is I didn't know much about his boyhood in Western initially Pennsylvania and then New York. And it's really kind of an amazing transition. There's no one in Jackson's family that has ever gone to college. They've all been farmers. His father opposes his idea to go into law, wants him to basically go back and get on the family farm. And Jackson resists this from almost before he's a teenager. But he's coming out of a family with no particular professional prospects at all. And look what he ends up doing. So I found that kind of very interesting.
Thank you. And that leads into another question from our audience. How did Jackson's reading and practicing law, rather than going to law school, the clerkship, and federal judicial route, influence his jurisprudence?
Yeah, I think he's always seeing the practical side of cases as a justice. And I think that comes right out of law practice. I call him in the book a constitutional pragmatist. That is, he's not inclined to let interpretations of constitutional provisions end up being absolutes. He sort of at one point he says, we need to temper our ideological commitments with a little practical reason, a little practical wisdom. And I think that all comes out of law practice.
Yeah, I think it made him distrustful of theory and sort of also someone, as I was saying earlier, who was more willing to kind of think about the problem with fresh eyes rather than just taking whatever the received wisdom was and just kind of blindly following it. And he was very critical of precedent, especially before he got on the court, when he wrote The Struggle for Judicial Supremacy and talked about how precedent was sort of like looking at fossils, to make decisions, which obviously wasn't meant as a compliment or praise. And so I think that stayed with him, you would think as a judge, he did, of course, have to be more respectful of precedent than he had to be earlier on in his career.
Thank you. Segueing a little bit further into his time at Nuremberg, did he have any impact or influence on the German legal community as a result of the work that he did on the Nuremberg trials?
When one of the things that they were considering at Nuremberg was to what extent the Nazi leaders would become perceived to be martyrs if they were summarily tried and not given an opportunity to defend themselves. But then alternatively, if they were given latitude to defend themselves, would they make speeches uh, trying to uphold Nazi ideology? Jackson wanted an American trial format um, where um, where in examination and cross-examination, defendants would be limited in their ability to digress from what was being asked. And the tribunal overruled Jackson at that point. On that point, they wanted to give the defendants as much latitude as possible in order to give the impression that they had a sort of full and fair opportunity to defend themselves. Jackson was furious in his cross-examination of Hermann Goering, for which he received some criticism because Goering who was quite mentally nimble at the time of the trials, would just respond to Jackson's questions by not answering them and going off on tangents in which he vindicated his own positions and the Nazi hierarchy and ideology. And Jackson sought to interrupt him, suggesting that these were irrelevant remarks, as he would have in an American trial. And the judges overruled him, and Jackson did not take kindly to that. Jackson was also concerned about what the effect in the German populace generally would be of the trials. Would there be riots in the streets about the Allied authorities, or alternatively, would there be people very disinclined to give any information about the Nazis? And he struggled with that. It turns out the German populace was, for the most part, sort of stunned and bewildered by the sudden collapse of the Nazi regime and the sort of its total annihilation, and very worried about what was going to happen to them under the new occupants of Germany. So really, Jackson didn't have much to worry about, but he went into the trial very concerned about that issue.
Thank you. We're going to wrap up in a few minutes. So if anyone has any last questions, please stick them in the Q&A box down below. What do you hope readers take away from each of your books? I'll start with Professor Magliocca.
Well, I think one question is what to think about executive power and its relationship to Congress. I mean, that is what the opinion is about. That's what Jackson spent a lot of his time thinking about throughout his career in all of its facets. And of course, it's a very important issue. It was in his time, it was in Watergate when the opinion became very well known, and then up through the present day. So basically, it's a reflection in part on the relationship between executive power and the Constitution, as well as executive power and Congress. Now, the other thing is Jackson, in the course of the opinion, does hit on many other themes that are kind of perennial issues in American constitutional law. The role of emergency powers and what we're supposed to think of them. The role of the president as commander-in-chief and sort of the relationship between civil and military power. How are we supposed to think about that? And so, as well as the sort of modern presidencies, and by modern, I mean, of course, he was talking about 20th century, but now you could say 21st century, relationship to the media or to kind of political parties and how those are kind of extra constitutional supports for executive authority that need to be considered when you're assessing a case. So really, these themes that he, in some sense, either was refining or kind of inventing in the opinion, are still very important in thinking about the problems of modern society. So I really want people to be able to understand the case and then reflect on that.
I would like to get audiences to get to know Robert Jackson again. I think of my book as a kind of attempt to reintroduce him. He's one of the unique figures in 20th century American legal history. Coming from the particular background he did, ended up doing so much in his career. Lots about him are just interesting in their own right. The manner of his death, for example, he died of a second heart attack. He had a heart attack in the spring of 1954, when the court was in the last stages of handing down Brown versus Board. And it was a serious enough heart attack that he was away from the court for 2 months. He only comes back to the court to sit while Brown versus Board is handed down. He then goes back into the hospital, recuperates over the summer, is prepared to join the court in October, and then suddenly dies of a second heart attack. And when he dies, he's in Elsie Douglas's apartment. It is a Saturday morning, and he has a second heart attack and succumbs. And Felix Frankfurter, who's his closest friend on the court, finds out about this and says to his law clerk, we've got a problem. We've got to kind of explain why he was in Elsie Douglas's apartment. So they delay putting out a statement for quite a while and then give a kind of self-serving explanation. So even the manner of his death is interesting. So I'm hoping people get to know him again. He's well worth knowing.
Thank you. I'm going to hold up your book, and I hope people will order it. And Professor Magliocca's book is currently not quite available yet. So I'm going to
available in ebooks, but not in not in
available.
hardcover.
Yes, I'm going to share my screen so you can see the cover of his book. Yeah, it should be available in a couple of weeks, and we will have it in our gift shop, as well as you can order it from Amazon as well. Thank you both for joining us. We really appreciate it. I will make a pitch that with the government shutdown, our gift shop is closed to the public. You should go visit it at supremecourtgifts.org. And this lecture will be on our YouTube page shortly, and you can visit the Society's website at www.supremecourthistory.org to find that. Again, thank you. We really appreciate you joining us, and we look forward to more terrific scholarship from you both in the future. We are adjourned.
Thank you.